I used a term, beyond a reasonable doubt. For anyone to be convicted in the United States of America, it must be proven more than probable cause. I'm playing the scales of justice here. Probable cause. Beep. More likely than not. Beyond a reasonable doubt. Beep. Not beyond all possible doubt. Beyond a reasonable doubt. Beep. Is everyone a reasonable person? Good. You've probably watched television shows, and we're going to see if you've been paying attention, and it's a quiz. All persons charged with crimes are presumed innocent. What? What's next? Y'all are kind of quiet. All persons charged with crimes in America are presumed innocent. Okay. Did I hear until proven guilty? You would be absolutely wrong. That's why I hate those Law and Order episodes. So people, they're entertaining, but they don't help us be smarter because they're wrong. You'll never make this mistake again. Here, this is how we're all going to learn. We're going to work today until 5 o'clock or unless 5 o'clock gets here. That term, those two terms have different meanings. Until means something is going to happen sooner or later. Unless means it may happen or it may not. All persons are presumed innocent unless proven guilty, not until. If you say until, you're wiping out the presumption of innocence because you're stating, oh, that person is going to be found guilty sooner or later. Not everybody charged with a crime is proven guilty. So the correct term is all persons charged with crimes are presumed innocent unless you find the defendant guilty. And that's written back in 1215 in the Magna Carta, when the people in England rose up against King John, who was not providing them, among other things, a proper fair trial by jury. And it's written in Latin, and there's the word nisi, is right in there. Nisi, which means unless. Donec is Latin for until, and it says in Latin, all persons charged with crimes are presumed innocent unless proven guilty. So 1215, that's, wow, there we go. You know, that's almost 1,000 years ago. So that's been the rule of law that we adopted. And the test, the other important thing is people who are jurors, after they had that right to be a jury, they were told, all right, listen to the evidence and decide whether a person is guilty or not of the crime. And they go, what's the test? I mean, or is it whim? Or is it, what's the test? How much proof should there be? And we have adopted the principle that evolved beginning in first written form in 1770 in the Boston Massacre trials, where the British soldiers shot 6 colonists here in America. And in that trial of murder, some of the soldiers were convicted, the British soldiers, which ended up developing into the Revolutionary War that brought our independence in 1776, and then later evolved to the United States of America in 1787. But in that trial, that first trial, John Adams was the defense attorney for the major who was in charge of the soldiers. And both sides argued for the first time it is written, if you're going to find anybody guilty, it must be based upon you believing the guilt was shown by evidence beyond a reasonable doubt. A couple of things that are interesting. Number one is that was a worrisome because of the people. The people were concerned. Our country is based upon really religious principles. The presumption of innocence is from the Old Testament. When our Creator is moving through the Garden of Eden and called Adam and Eve forward. What have you done? We look at that as our Creator gave Adam and Eve an opportunity to be heard before rendering decision on their fate. We as humans should do no less to someone charged with a crime. So the presumption of innocence is directly taken from the Old Testament. Book of Matthew, New Testament. Judge not lest ye be judged. Jurors did not like having the burden of a person's future in their hands, especially when they had to make a decision on one side or the other, because there's going to be one side arguing one way and the other side is going to be arguing a different way. People did not like that responsibility based upon Matthew. So they came up reasonableness, John Locke, and that time in the 18th century of a determination, let's use human reasonableness and education and wisdom in making decisions, deliberate and thoughtful. So that was the first time it was argued in a trial that beyond a reasonable doubt should be the test, not beyond all possible doubt, but more than probable cause, but not beyond all possible doubt, beyond a reasonable doubt. It's very interesting also for history. I like history because I always want to know, how did things get to the way they are, especially in law? You know who the first person was who was shot and killed in the Boston Massacre, which began the fight for liberty, the Revolutionary War that turned into the United States of America, for which we enjoy and are part of to this day? First person shot right in the chest and killed was a man named Crispus Attucks. Anybody ever heard of Crispus Attucks? He was an African American. He was not a slave. He was a sailor. He believed in a dream of freedom, like others, and he protested and was shot in the chest and killed. First person who died in what later became our free country. So yes, we are in this together, and the rules of law are applicable for everyone, and no one needs to tell me otherwise. I remember one day I come to work on a Monday. Mike Bradford was the U.S. attorney, and I was criminal division chief for the 43 counties of the Eastern District of Texas. And Mike said, come in here right now. And Mike never had that sense of urgency. So I walked in and he goes, sit down. And I said, okay, yes, sir. And he was my good friend. And there was a sense of urgency I'd never seen about him. And he's on the phone and he goes, Ms. Reno, John Stevens is here. And I go, Janet Reno? The Attorney General of the United States doesn't call us. She calls the President of the United States every day, not us. And she said, something terrible has happened in Jasper, Texas. Get the FBI, go help those people and make sure that justice is done. And I'm not kidding you. I wanted to salute. Yes, ma'am. And so we had that experience of the trial of the century, they called it. And they called it that, I think, because it was the end of the century. It was in 1998. But that Constitution had been knocked out of balance by three bigots who did a terrible thing to a human being. And they crossed the very foundations of what the Declaration of Independence and the Constitution stood for. And we had to fix that. And we couldn't bring life back, but we could certainly make sure that justice was done. And I'm not a big believer at all in the death penalty, but I asked for it, and those two have been executed. And it just, I believe in the sanctity of life, but when you swear to hurt other people whenever you get a chance just because of their race, which slams against the foundation of the Constitution, future innocent lives have to be protected. So these laws are important. They're meaningful. And we've talked about the ideals that they stand for. And I can tell you, there are situations we all are called upon to deal with the actual fallout from when the Constitution and the laws of the United States and Texas have been breached. Juries come forward and make a decision whether they have or not. And by following the law, whether a crime has been committed beyond a reasonable doubt, which is going to be your test. Now, I'm going to ask you right now, this is going to be a test on the presumption of innocence here. All persons are presumed innocent unless they are found guilty beyond a reasonable doubt. Now, the defendant there's been no evidence presented, so he sits here. My question is this to you as the test. Is the defendant guilty as he sits here? Or right now, the state of the record being no evidence presented. Is he not guilty? Or is it the third? There is not enough evidence yet to determine whether he's guilty or not guilty. All persons are presumed innocent unless proven guilty. Who thinks it's number one, he's guilty right now? Who thinks it's number two, he is not guilty right now? Who thinks there's not enough evidence to make a decision one way or the other? Put your hands down. All persons are presumed innocent unless proven guilty. You haven't heard one word. If I ask you to vote right now, there's only one choice you can make. He is innocent, not guilty. And that will not change unless evidence is presented convincing you he is guilty of what this crime is alleged to be. That's a test. That's okay. You learn and you'll make an A next time.